to another episode of Tea Time with Tangie. Thanks for tuning in today. Make sure that you like and share and subscribe to this channel if you find that it is of benefit to you. I definitely appreciate all of the support. But before I begin today's tea, let me just start off by saying that this video is solely intended for general information. I'm not providing any legal advice, nor does this provide or create an attorney-client relationship. This is just strictly general information. I am licensed in Maryland and DC, so I am an attorney, but again, this is just general information. So now that I got that out of the way, I hope that you grabbed your favorite cup of tea because, you know, on this channel, I like to have a nice cup of tea while I serve you the legal tea. And today, I'm drinking on organic chamomile tea. I'm going to need it because there's a lot of commotion going outside of my window. They're doing some construction today. Of all the days that I'm recording, they're doing construction outside, and it's really loud. So I'm gonna need this chamomile tea. It's supposed to relax you and keep you calm and stress-free. So hopefully that it works. Nevertheless, let's go ahead and get into today's topic, and that is why every adult should consider having a last will and testament, which is just another fancy word for a will. Now, I know a lot of people think that estate planning is primarily for the wealthy, but that's not the case. Estate planning is for everyone. So I think, especially if you're a young adult with children, you really should invest in doing estate planning. But again, it's just not for the estate planning is not just for people who are wealthy. So today I'm just going to be sharing some information about what you need to know about wills. So I'll be discussing what the purpose of a will is, who should have a will, what happens if you die without a will, what can and may not be put in a will, and then what makes a will valid. So again, this is all going to be general information. And also understand that estate planning is very state specific. So if I do give anything specific, it will be Maryland based. But I will let you know that as I go through today's video or information. And then, excuse me, I probably should drink some of this tea, huh? And then just remember, I'm not telling you that you need to go and get a will or what you should put in your will or anything like that. These are just suggestions that I think would be helpful if you are in the pursuit of estate planning. All right, so let's go ahead and get started. Okay, so what is the purpose of a will? Basically, a will is just a legal document. It's going to coordinate the distribution of your assets upon your death, which just means that when you die, because we all are going to die one day. Yes, I'm sorry to say it, but we are going to pass away. None of us live forever. But it's just saying that when you pass away, the will is going to tell, it's a document that's going to tell people where your stuff is supposed to go. Okay. And then you can also have appointments for minor children. So you can appoint guardians for minor children. And I'll talk about that in just a second here. But basically, the will is just going to let your wishes be known as to who should gain possession of all the stuff that you own when you die. It also will allow you to name someone who you believe is trustworthy and impartial, okay, to oversee and manage the distribution of your estate. So you want to pick somebody who's going to be able to facilitate how everything is supposed to go when you pass away. And that should be somebody that you trust, and that is somebody who's going to be impartial and won't, be able to be told what to do by other people. Okay. So, and then back to the appointment for minor children that I just briefly discussed. If you do have minor children and you pass away, and let's say the other parent cannot step up to get custody, because a lot of times when you pass away, and if the other parent is available, then that person would get custody. But there are reasons that may not happen. Maybe the other parent is also deceased, or they're in prison, or they they don't want to, they want to, they don't even want to have anything to do with the child, which would be very unfortunate, but that happens. So, whatever the case may be, you can appoint a guardian in your will. So that is the purpose of a will. Okay, so who should have a will and what happens if you die without a will? Well, every adult, no matter how young or how old you are, you should have a will, or you should consider having a will. And you should have a will created now while you are in your right mind, while you are healthy. You don't want to be creating a will while you're on your deathbed. Okay, that's probably not the best time. So now is the best time. If you are in your right mind and you're healthy, you should consider getting a will. If you die without a will, which is known as dying intestate, the law is going to decide your estate and the law is going to decide how your estate should be distributed. And if you have certain things that you don't want going to certain people, you probably should look into getting a will. And if you die without a will, this is definitely going to complicate things. It causes a lot of stress for families, a lot of division in families. I've seen it with my own family, so I've experienced it personally, and I know that dying without a will can cause a lot of issues, especially if you have a lot of assets and if you have minor children. So maybe you don't have a lot of assets, but you have young children. Again, it's really important that you really consider getting a will now than later. Okay? All right. So what can you put in a will and what should you not put in a will? You want to include your estate assets, of course. Those are the things you want distributed to your beneficiaries. You want to name your beneficiaries in the will. And you also want to nominate a personal representative. That is the person that I spoke about early on. That is the trustworthy, impartial person who's going to oversee the distribution of your estate. So you want to put that in your will. It's very important that you know what assets you own. So you actually need to own your assets, okay? How they're owned, and which of these assets will pass under a will. It's important to know that not every asset you own will pass through a will, because there are things like contracts, deeds. You might have co-ownership of some of the things that you own, and then you might have already designated a beneficiary outside of, your will to these particular assets. So again, there's like certain assets that you already have a way of being transferred to someone without them being included in your will. And those are things like life insurance policies, any type of financial assets, like a retirement account, a bank account, stocks and bonds kind of things. You may have already had those things designated to a particular beneficiary. So you don't want to put that in a will. You should also exclude property that is jointly owned with someone else, or property that's held in a trust account, or, anything that someone receives separately from the will. You don't want to put that in the will, because what could happen is that, let's say you have a bank account and you want to give, let's just say Harry, call him Harry. You want to give Harry all of the money in your bank account, right? And so you put it in your will and say, Harry shall have all of my money in my bank. And then, but you also had, when you opened up your account, you put Sally as, the payable, it's called a payable on death payee. You put Sally on that POD of your bank account, right? So when you die, Harry and Sally are both thinking that they're going to get the money in the bank account, but it's actually going to go to Sally and not Harry, because Harry's, even though he's in the will and you said that he should get the money in the bank account, the POD with the bank actually is going to trump that. So you got to be very careful with what you're putting in your will to make sure that it is not already designated to someone else, because then you're going to have those conflict issues come up. Okay. So you also may want to put in burial instructions, but and you can put it in there, but it's probably more wise to put it in like a living will, which is like an advanced medical directive. You might want to put that in there because your loved ones will need to make decisions promptly upon your death. And anytime you put things in a will, it has to go through probate. And probate, it can take a while, right? So if you have and someone may not be reading your will right away or any of that. So they may not even get to your wishes in the will. But if you put it in like maybe a living will also, so you can put it in your will, but you can also put it in your living will, that kind of will help with the burial instructions. So that is, pretty much that about what you should put in the will and what you maybe shouldn't put in the will. Okay, so we're on to the last part of this video, and that is what makes a will valid. Basically, your will needs to be properly executed. If it is missing the formalities that are required for it to be valid, then it's going to definitely not be valid. So you need to make sure that you execute a valid will. So it's important that you understand the requirements in your state that it takes to make a will valid. You need to make sure that you know what language needs to be added in that will to make it valid. And also, it's probably a good idea to speak with a licensed attorney in your state to make sure that you are, especially if you're going to create your own will, at least get legal advice on what you need to make sure that it's valid. Because the last thing that you want to do is draft your own will without any legal guidance, because it happens all the time. People, they want to be, their own attorney, which is fine, I get it. I totally get it. But you want to make sure that you're doing the right things so that your will is not invalid when you pass away, because you don't want your stuff going to the wrong people, and you don't want to also cause stress, stress and heartache with your family, with having to fight to figure out who's supposed to get what and all of that stuff that happens. And we all know it happens because people act up when you pass away. So please make sure that you are getting some type of legal advice or guidance if you're going to draft your own will. Generally, most wills, they must be in writing, they must be signed by you, and they must be witnessed by at least two people. That's the general formalities of a will. However, every state is different, so it's really important that you look to what your state says about what makes a will valid. In Maryland, a will is valid if it's in writing, you signed it, and then it's attested and signed by two credible witnesses. So it could be handwritten or typed, and any two adults can witness it. Now, with the witnesses, I would suggest that they be witnesses that are not your beneficiary. So no one who's getting anything in your will should be witnessing your will. That's just my preference. Again, you have to check what is allowed in your state. And that's just what I would prefer, is that you don't have someone who is going to be benefiting and also witnessing, because it could cause some kind of, people to contest things, right? Unless you have a no contest clause in your will, which is a whole nother topic. But also in Maryland, your will does not need to doesn't need to be notarized. However, a will, it can be, your notary can act as a witness. And then also I know electronic wills, oral wills, video wills. So like people on their last, their deathbed, and they just want to make a recording to say, I want X person to have this. Those are not valid in Maryland. But again, every state is different. So it's really important that you check with your state's rules on or laws on what makes a will valid. And that is it for what makes a will valid. Well, I have come to the end of my tea time with you guys. And as always, please like, share, and subscribe. It goes a long way. The support, it means a lot. It's very helpful in getting out the content to others so that people can see it. And maybe you don't need a will. Maybe you already had a will, but if you know someone who may need a will or should have a will, maybe this is something you could share with them. But I definitely appreciate you guys for giving me your time, and I hope that you have a blessed rest of the week. Make sure you tune in. I drop content every second and fourth Thursday of the month. And so I don't really know what my next topic will be. Maybe I'll talk about trust. I'm kind of keeping with the theme of estate planning, but I also do immigration and family law. So, and because my firm is based solely on, all things family. So I'm all about the family unit. So I'll let you guys know what I'm going to be posting, but, again, thanks for tuning in and take care. Bye.